we're going to talk about what an injunction for protection is, the different types of injunctions that we have in the state of Florida by law, how you go about the process of requesting an injunction for protection, and if somebody has been served with an injunction, how you can defend against one. And then we'll have some time for questions at the end. But first I'd like to start telling you a little bit about, it's backwards, the Clerk and Comptroller's office and our self-service center. The Clerk and Comptroller is the trustee of the county's public records and public funds. And one of the services that we offer is our self-service center. It's located here in West Palm Beach on the first floor of our courthouse, and we also have one at all of our branch courthouse locations. At the self-service center, we have numerous different packets on different areas of the law that include the forms that you need to file a case in that area, as well as user-friendly instructions that can guide you through the process if you can't afford an attorney or would like to represent yourself. And on your tables, one of the two forms that you have is actually a list of all the different packets that we offer, the title of the packet and the cost, okay? It happens to be that injunctions for protection are free forms, and so those are not included on the list. I do have all the different kinds of injunctions there on the table, if anybody would like to take one. And I will show you throughout the presentation that all the forms are also available for free at all the courthouse locations as well as online. The Self-Service Center also provides public access computer where litigants can look up their case if they have any questions about it. There's also, in most of our locations, a station where they can e-file. We have attorneys that provide low-cost consultations. What that means is they can guide people through the form packets that we sell, so they can help people fill out the forms. Because the clerk can only provide ministerial services, they cannot give any legal advice or represent anyone in court. Just help them with the procedural information on the forms. And that is $1 per minute in increments of 15 minutes. For some of our more complicated matters like divorce, we usually recommend that they start at 30 minutes because it takes a little longer to complete the packet. And we have notary services. We can make copies for people of court forms as well. Okay, so first let's talk about what an injunction for protection is. An injunction for protection is a court order that basically protects the petitioner, the person asking for the injunction, from the respondent by telling the respondent that they have to stay away a certain distance from the petitioner, their home, their work, and other locations that they can request in that petition. It may also prohibit the respondent from having any kind of contact with the petitioner, in person, by text, through a third party. That's going to depend on what the person requests in their petition and what the judge ultimately orders. Oftentimes you hear people talking about restraining orders when they're talking about injunctions for protection. In Florida, we use the term restraining order for criminal injunctions usually, and the civil ones are called injunction for protection. But it is a form of a restraining order. There are other things that can be requested in injunctions. Sometimes they may give the petitioner temporary exclusive use of a home, especially if the parties are married and they both own the home. It may give them temporary sole parental responsibility if there are children involved, temporary child support, or temporary alimony. These are things that the petitioner could potentially request when they fill out an injunction. These injunction requests are civil proceedings. They're not criminal proceedings, which mean when the petitioner and the respondent show up for a hearing, if the injunction is granted, the respondent is not going to get arrested at the end of that proceeding because it is a civil proceeding. But if the injunction is granted, it is then a court order, and if it is violated, then the person who is protected by the injunction can call the police and the person would be arrested because now it is a criminal offense. Okay, but that's not going to happen at the actual injunction hearing. It is a civil proceeding. There are 5 types of injunctions in Florida, and we're going to go through each of these today. I'm going to define what they are, and I'm going to explain what forms you would need to fill out to request each of them. The first kind, the kind you hear the most about, is a domestic violence injunction. There's also a dating violence injunction, a repeat violence injunction, sexual violence injunction, and a stalking injunction. And I'll take a brief break because I notice everybody writing voraciously. You can take notes. I love to take notes, but I just want to let you know that this entire PowerPoint presentation will be online on our self-service website, all the slides, and you can just print it out when you get back to your office or reference it whenever you'd like. Okay? So we are going to start with the injunction for protection against domestic violence. Okay? So the legal definition of domestic violence here in Florida is assault, battery, sexual battery, stalking, kidnapping, false imprisonment, or any other criminal offense resulting in physical injury or death to the petitioner by someone who has the following relationship with the petitioner. So we're going to talk about the relationship now, because which injunction someone chooses has to do a lot of times with what relationship would they have with the person they want to restrain. So for a domestic violence injunction, you have to have either live or have lived together as a family, are either married, formally married, or related by blood or marriage, or you have a child with the person. So if you have a child with someone, you can get a domestic violence injunction even if you never lived with them or were never married to them. The residence requirement is not there if you have a child in common. So the domestic violence injunction is usually for family members, household members, people who are part of a family unit and who have domestic violence occurring in their relationship. For most injunctions, in addition to a relationship requirement, there's a violence requirement as far as what had to have happened for you to be eligible for the injunction. And for the domestic violence injunction, you have to have either been a victim of any act of domestic violence, as we just defined it, or have reasonable cause to believe you are in imminent danger of becoming a victim of domestic violence. So you would have to be able to explain to the judge certain things that have happened that make you believe that an incident of domestic violence is imminent, going to happen soon. There are multiple forms that you would need to fill out to get an injunction for protection against domestic violence. The main document is the Petition for Injunction for Protection Against Domestic Violence, which is Form 12.980A. Okay. There are some additional forms that you have to fill out in all family law cases. That would be the date of birth form, the cover sheet for family law cases, and the notice of related cases. In Florida, there are some statutory reasons why you may be able to have certain information on your petition held confidential, like your address. If you qualify, you may have to fill out one of these two forms, a request for confidential filing of address or a notice of confidential information. What you should do is read the instructions. It tells you the statute and who qualifies, because it's not an automatic thing. And if you feel that you qualified and wanted your address to be confidential, then you would need to fill out one of these additional forms. If you have minor children with the other party, there are even more additional forms that you would have to fill out that would specifically address the children that you have in common. One of them is the UCC JEA declaration. That form asks where the minor child or children have lived in the last 5 years and with whom. It helps the judge make any kind of temporary parental responsibility orders that they may have to make, visitation orders. Also to make sure that they have jurisdiction over the case, that this isn't a child in which there are orders in another state about. There's also the notice of Social Security form and a parenting plan if you want to request that the judge make orders about parental responsibility and visitation. Then on this form you can specify what you would like that to look like. There is a regular parenting plan, but there's also a safety-focused, supervised visitation parenting plan that you can get online or at the courthouse that is more tailored to a situation where you think the child may also be in danger or needs to be supervised in the presence of the other parent. And finally, if you're requesting temporary child support or alimony in your injunction, then you would have to fill out a financial affidavit that talks about your income and expenses, and at some point prior to the hearing, fill out a child support guideline worksheet to figure out how much child support would be appropriate in the case. Okay? And as I mentioned, all these forms are available for free at the clerk's office, and then this is the website that I was referring to. The Florida Courts website has all of these forms there for free. Also, there's on the mypalmbeachclerk.com website, there's a link to the forms, and you can actually fill out the forms online. They're interactive. You can't file them from there. You'd still have to print them out, but that would make it easier to complete them. Okay, now we're going to discuss the injunction for protection against dating violence. As far as what the definition of violence is, it's the same as for a domestic violence injunction. So battery, assault, sexual battery, all of those things would count. But the relationship requirements are different. So this is someone that you don't live with as an intact family, or you're not married to, but you do have an intimate dating relationship. And the law requires that you either have or formerly had a continuing and significant relationship of romantic or intimate nature, and that the dating relationship must have existed within the past 6 months. So this would not be the injunction for someone that you went on one date with and then everything went horribly wrong, but someone that you had a continuous relationship with that ended sometime within the last 6 months or that is still ongoing. The violence requirements are very similar to the domestic violence injunction. They're only slightly different. You have to be a victim of an act of dating violence and have reasonable cause to believe you're in imminent danger of being a victim of another act of violence, or have reasonable cause to believe you're in imminent danger of becoming a victim of dating violence. So whereas the domestic violence one, it was either you've been a victim or you have reasonable cause to believe that you're going to be a victim. For dating violence, you always have to express that you are concerned that it's going to happen again. Even if you've already been a victim, it still requires that you express that you have reasonable cause to believe that it's going to occur again. Now for the forms, the only main form that is different is what petition you would fill out. So you would fill out a petition for injunction for protection against dating violence, which is form 12980N. The other required forms are the same forms that I discussed for the domestic violence petition. So no matter what injunction you apply for, you're going to have to fill out the date of birth form, the cover sheet for family law cases, and the notice of related cases. And for whatever injunction you filled out, if you needed certain information to be confidential and were eligible, you would have to fill out one of these forms regarding confidentiality. So that, for all the injunctions that we discussed today, is going to be the same. Now if you notice, before we move on to repeat violence, I didn't list any forms about minor children, because if you have minor children with the other person, you're going to apply for the domestic violence one. Even if your relationship meets that dating requirement, if you have a child together, you're going to apply for the domestic violence one. So then we have the injunction for protection against repeat violence. Same definition of violence, but there is no relationship requirement for the repeat violence. So you don't have to know this person intimately. They don't have to be part of your family. It could be your neighbor. It could be an acquaintance. It could be your cousin's best friend's girlfriend that you met one time. So the relationship between you and the person does not have to exist. But there are violence requirements that are a little bit higher, which are there has to have been at least 2 incidents of violence between you and this person. And at least one of those incidents has to have happened recently, specifically within the last 6 months. Okay? And this could be all different kinds of situations, but you see a lot of them. It is neighbor disputes. And the main form that would be different for the injunction for protection against repeat violence is that petition. It's going to be the petition for injunction for protection against repeat violence, which is form 12.980F. All the other forms would be the same. The fourth injunction that we have here in Florida is the injunction for protection against sexual violence. There is a different definition for violence, a statutory definition. I have it up there, which includes sexual battery, any kind of forcible felony that includes a sexual act, any kind of sexual act in the presence, or including enticing a minor and things of that nature. And there is no relationship requirement. You don't have to have an intimate or familial relationship with the person. Really, the only thing, you do need to know the name of this person because you're applying for an injunction for protection against them, but you don't have to know the person well. There are a lot more requirements for the injunction for protection against sexual violence. It requires not only that you have been a victim of sexual violence, but that you reported it to the police, and that if criminal charges are pressed, that you cooperate with the criminal investigation, which is the one that, you know, makes it a little bit more difficult for some people. Or if the abuser went to prison for the sexual violence and has either been released or is about to be released within the next 90 days, you can apply for an injunction for sexual violence, even if the case that they went to prison for was not the case having to do with your incident. And the petition that you would use for this injunction would be the Petition for Injunction for Protection Against Sexual Violence, which is Form 12.980Q. And then we see the forms that we've seen for all the other injunctions as well. Okay. The final injunction for protection we have here in Florida is an injunction for protection against stalking. And stalking includes cyber stalking. So this is something that has become more prevalent as especially young people use technology a lot more for kind of dating relationships. So stalking, as defined by the law, is the repeated following, harassment, or cyber stalking of one person by another. But then it specifically defines cyber stalking and says that it's to engage in a course of conduct to communicate or cause to be communicated words, images, or languages by or through the use of electronic email or electronic communication of any kind directed at a specific person, causing substantial emotional distress to that person and serving no legitimate purpose. And we're going to go into those requirements in a little bit more detail in just a second. So there is no familial or intimate relationship required, again, for the stalking. You don't have to know this person. The other requirements that we kind of saw in that cyber stalking definition are that the stalking must be repeated over time. So if a person follows you once, that is not considered stalking, or writes on your Facebook page once. Stalking is a pattern. The definition says continued harassment. It can have no legitimate purpose, and it has to cause you severe emotional distress. So those are the things that you would have to explain to the court in your petition. Legally, this is a relatively new area of the law, so there aren't that many cases that define for the judges what a legitimate purpose is. So it's a little bit of a gray area at the moment. As far as what petition you would fill out, it would be the Petition for Injunction for Protection Against Stalking, which is Form 12.980T. Okay. So those are the 5 different types of injunctions, and we broke down who qualifies for which kind. And now we're just going to talk about the process here in Palm Beach County to request an injunction for protection. Okay? So the first step, obviously, is that you have to fill out the forms. You're going to fill out the appropriate petition and any of the other applicable forms that we discussed. There is some limited assistance. The clerk's office or victim services office at your courthouse may be able to assist you with procedural information on how to fill out the forms. Okay, they can tell people certain information, but they can't give legal advice, and the clerk cannot fill out the forms. The clerk cannot fill out the forms for the person. Okay. The forms are going to ask you to specify dates when the incidents occurred, to detail what happened, who was there. So it's a good idea that if you have a police report or hospital records or a friend who was there or any notes, that you bring whatever evidence you have with you, because it's going to help you complete the form. Once you have filled out the petition, you're going to take the forms and you're going to file it with the clerk's office. And the forms are filed, even if it's one of the ones where you don't have a familial relationship with the person, all injunctions are filed in our Unified Family Court Division. That here in this courthouse is on the 3rd floor. There's no fee for filing an injunction, so it is free. The clerk is going to take your paperwork and is going to submit it to a judge who's going to review it. And normally, depending on what time of the day you submit it, that happens the same day. So generally, you do have to come back the same day to pick up your paperwork and see what the judge decided. To ensure that you get this done the same day, we advise that you try to file your petition well before 4 o'clock because the clerk's office closes at 4. That way you're certain that it doesn't have to wait till the following day. Now, once your petition is up with the judge for review, there's 3 possible things that the judge could do with the injunction. The first is the judge could grant a temporary injunction. That means that there will be a hearing set. Normally, it's supposed to be set within 15 days from when you applied. There are some limited exceptions where the judge can extend that time by agreement of the parties or some other unilateral reasons, but the judge will make an order if they're going to set it further than 15 days. Okay? But normally it will be set within 15 days, and if the judge grants a temporary injunction, that means that you have an injunction that's going to protect you from the day you pick it up until the date of the hearing. Okay? That's one possibility. There's the other possibility that the judge may deny the temporary injunction, but still grant you a hearing to decide if a final injunction will be issued. So based on what you wrote, the judge may not have felt that you were in imminent danger and needed something now without having a hearing where the judge hears both sides, but they still feel like there's enough that there should be a hearing and see if an injunction should be granted. So they will set a court date, but there won't be a temporary injunction granted. And then the third possibility is that the judge could decide to deny or dismiss the petition altogether and not grant a temporary injunction and not set a hearing. Okay? If the judge does not set a hearing, there's going to be like a cover sheet that will explain why. Maybe not in detail, but it'll, say that it was denied. And if it is denied, then if the petition is dismissed without a hearing, then your petition will be confidential. It will be made confidential by the court, which means the other party won't be able to see what you said in your petition, since there's not going to be a hearing and an injunction granted. I'm going to skip that. If the judge sets your petition for a hearing, then the clerk is going to forward copies of your petition to the sheriff, and it's going to be served on the other party. So there is a information sheet that you fill out to give the sheriff as much information as possible about the other party, so that will assist them in locating and serving the other party with the injunction. If the judge denies your petition, it's usually without prejudice, which means you can apply again in the future if something changes. Okay, so we talked about the requirements. Some injunctions require 2 or more incidents, or continuing stalking. So maybe it didn't rise to that level yet, but if something changes, you can come back and file again in the future. Or if you need to correct any errors that caused the denial, you can reapply in the future. But you may also file a supplemental affidavit in support of your petition, which is Form 12.980G. This is a form that allows you to add facts or clarify things in your original petition, and then the petition will go back up to the judge for a second review. The final step in how to apply for an injunction for protection, the most important step, is that you have to show up to your hearing. So if you do not attend the hearing that was set, the judge will likely deny or dismiss your petition because you're not there to answer any questions or present your case. Okay? The judge will likely ask you some questions about your petition, and remember, because the other party was served, they may be present, so you may have to see and face the person that you're asking for the injunction against. Okay? Just like we mentioned for when you're filling out the petition, if you have any witnesses or evidence that you want the judge to consider, then you will need to bring it to the hearing, because that's your one shot. And you are allowed to bring a support person or an advocate, and they can sit in the audience. But unless the person is your attorney of record and they're an attorney, they can't speak for you with the judge. You'll have to do the speaking yourself. Okay. We covered all the different kinds of petition, but there are a few miscellaneous forms that I wanted to address. One of them is a motion for extension of the injunction for protection. Basically, injunctions are granted for a certain amount of time that the judge will specify in the final injunction. It could be 1 year, it could be 3 years, it could be 5 years. Occasionally a judge could issue a permanent injunction, but it is not that common. If you're getting close to the time when the injunction for protection is going to expire, but things have occurred that give you reason to believe that you still need the injunction for protection, you could fill a motion to extend the injunction. Motion for modification of injunction for protection. This form can be filled out by either party. It's basically, you're asking the judge to change one of the terms in the final injunction. So something that the judge ordered, whether it be about the injunction itself or some of the other requests that were made, you need it to be modified. This is what you would file. And finally, a petition by affidavit for order to show cause for a violation of final judgment of injunction for protection. That is a mouthful. But basically, if somebody violates an injunction, you can call the police. It's an order, and violation of that order is a crime. You can call the police, who may arrest the person. And there may be criminal charges that come out of that, but that decision is ultimately made by the state attorney and the prosecuting agency. But you can also take a civil action if you file an order to show cause to bring the person back to court before the judge regarding their violation. And that would be the form that you would use. Okay. If you're on the other side and you were served with an injunction for protection, know that the court can't just issue a final injunction based on the petition. Okay? The most they can do just based on what the person wrote is issue a temporary injunction. They cannot issue a final injunction without service on the respondent and a hearing where the respondent has the opportunity to show up and be heard. If you are served with an injunction for protection petition and you believe you're being falsely accused, or you disagree with any of the terms of the injunction, you must show up at the hearing and explain to the judge your side of the story. If you don't show up to the hearing, there's a high probability that a final injunction could be issued in your absence. If you attend the hearing, then both sides will be able to present their case to the court, and if you have any witnesses or evidence that you would like the court to consider, then you should bring that to the hearing as well. If you would like to file a written answer in response to the petition prior to the hearing, you can do that, but there is no pre-made Supreme Court form like all the forms that we discussed for requesting an injunction, so you would just have to create an answer of your own creation and file it. It's not required. You can just show up to the hearing and you'll still be allowed to speak. And there's no filing fee for filing an answer as well. Okay. If you'd like, you can hire or bring an attorney. Both sides can, but it is definitely not required. Even if you feel that you were wrongly accused and really the other person was the person who was the abuser, you can't, at the hearing for the injunction against you, tell the judge, I want an injunction against, it's really the other way around, and I want an injunction against the other person. You can't ask for an injunction in your answer. If you feel that you were actually the victim of the domestic violence or any of the other kinds of violence that we discussed, you would have to apply and fill out your own petition and go through all those steps, have it served on the other party if you want an injunction against them. Okay? So we covered the 5 different kinds of injunction, what the relationship requirements are, the violence requirements, what forms are needed, and the procedural process. I just have some helpful links for you here. And as I mentioned, this presentation is online on our My Palm Beach Clerk website, on our self-service page. And eventually the recording will be as well, if you need other people to watch it who couldn't be here today. So the first website that I mentioned previously is the Florida Court's website, and that's where you can, one place where you can get all of these forms that we discussed today for free. or you can access them through the mypalmbeachclerk.com website as well. There's the Florida Coalition Against Domestic Violence. In Florida, all domestic violence shelters are registered and certified. There's at least one in each county in Florida. And they're all listed on this website. So if somebody needs to know the address of their local shelter or how to contact them, you could access that information on that website. There is the Florida Coalition Against Sexual Violence, which assists and oversees the rape crisis or sexual violence centers in the state of Florida, which are also all certified and registered and are available on that website. And then we have 2 domestic violence centers here in Palm Beach County. One of them is AVDA, Aids to Victim of Domestic Abuse. That's their website. YWCA Harmony House is the other one, and that's their website. Both those websites are safe for victims of domestic violence. They all have easy escape buttons if somebody is concerned that they're being watched. And finally, this is the Florida Domestic Violence Hotline. If there's an emergency, it will connect someone to one of the domestic violence shelters. They also have a legal branch. There's a Florida Domestic Violence legal hotline branch that if you call that number, they can connect you to as well if somebody has legal questions about their injunction case or their criminal case. They can give them general information. They can't give them personalized advice. Okay. So that's our presentation today. Does anybody have any questions? Yes, ma'am.
The stalking injunction.
Yes.
Is that just if something is directed towards the individual? Well, let's say if someone is wanting to make a problem for another person and they're calling people, their family members, their employer, their, and causing a problem for that person, but not necessarily calling them directly.
Well, ultimately, that would be up to the judge. But, I don't want to say, yes, that would definitely be granted. But the statutory definition does say harassment, and it does say it has to be directed at a specific person, but it doesn't say necessarily that they have to be calling that person. So, there is the possibility that you could harass someone through another person continuously for no legitimate purpose in a way that causes them severe emotional distress. So just based on the statutory definition, it would appear that it could be from another person, but ultimately the judge will decide that when the person says the specifics of their case. And I wouldn't guarantee that the judge would think that that would be enough or not. Especially with cyber stalking right now, or contacting people electronically, like I mentioned, it's a relatively new area, so there isn't that much case law to define what would be enough and what wouldn't. There's a little bit of case law if you look it up. But.
And then for the situation that domestic violence, can you give any examples of what might be considered a threat but not? I had always heard that for like a restraining order that someone actually had to be hurt. And I work with family members, right, people with mental illness, and they're threatened, their lives are threatened fairly regularly, and some of them I think have some pretty legitimate concerns. Right. So
according to the statute, they don't have to be hurt. Reasonable cause to believe that you're going to be hurt is sufficient according to the statute. Now, if you read case law, it's harder to prove your case if you haven't actually already been a victim of an incident, because you have to kind of explain the threats and the cues, and it's a little less tangible than a bruise or a police report, or So I will be honest that it is more difficult, but it's definitely possible according to the statute. And we would never advise we would never advise anybody either way, but we would never advise or discourage anyone not to apply just because it's only been a threat. Some threats are very specific and result in, catastrophic events. So, any other questions?
Well, with regards to the repeat violence, I guess it's questioning or concern, I guess, to together. So it says that it's 2 incidents of violence is one of the requirements. So what if somebody comes to the person and they beats them up and there's nothing actually legally happens?
Right. Well, if somebody beats someone up once, especially in repeat violence where you don't have an intimate relationship or a familiar relationship, that's still a crime. Most definitely you can still call the police and there may be charges against that person for assault. But for an injunction, which pretty much puts a lot of limits on the other person's freedom of movement, the court and the legislators have just decided they don't want it to be one isolated incident. There was a heated moment at a restaurant, 2 strangers got in a fight, and you're never going to see this person again. You don't know where they live. So there's no future threat. They don't want to use the injunction, which is why they put that requirement of 2 or more incidents. So there has to have been at least a second time where it happened. But that doesn't mean that if there was just one isolated incident that someone couldn't press charges against someone and the state attorney couldn't decide to prosecute it that way. They just wouldn't qualify for this long-term injunction. Anybody else?
Well, is this the same as a restraining order, or is that?
It is. Injunction for protection is the name that Florida has for civil restraining orders. Okay. Some states call them restraining orders.
If someone does continue with seeing the person or whatever, then the police can be called.
Yes.
And
the person will be arrested because they violated the court order. And it is a misdemeanor most of the time. Their criminal charges can be placed against them. Well, depending. If there's actually another incident of physical violence, it may be higher than a misdemeanor. But just a violation of the injunction itself is a crime. Correct. Anybody else?
do you need a copy? You should have a copy of that then. So if you call the police,
That's a good question. That's a good question. When you should always have a copy of your injunction with you. It's sad, but you should keep it in your purse. If there's children involved, you can give one to the school. It goes into a system. So, if the police gets called, they can look it up. But, there are problems sometimes, and actually sometimes it takes a little while to get in the system. So it's always advisable that you have a physical copy of the injunction that you can show the police. But yeah, you can just call the police like you would for any other crime being committed, and then, show them the copy of the injunction.
And then what happens if the person is, the injunction goes through and the person didn't show up and at the hearing, and basically, what if the police never find this person to tell them that there's a hearing, and then they don't show up at the hearing?
Well,
it still carries, right?
The judge cannot proceed with the hearing if there's no proof that the respondent has been served.
Has not been served?
If the respondent has not been served,
okay.
At the date of the hearing, the judge can't have the hearing anyways, because due process requires that somebody who's being accused of something, has the right to know about it, have notice, and at least the opportunity. It's different if they were served and they don't show up to the hearing, but if they don't, and there's different ways that judges deal with that, right? Sometimes if the judge feels like this person is just being evasive but can be found, they will continue the hearing. That's one of the grounds where they might, and give you more time to find the person. Okay, it may get to the point where there's been so many continuances that the judge really feels like this person is no longer going to be coming around, and the judge may deny it without prejudice so that you can reapply if the person does reappear. But the judge usually will give you opportunities to continue to try to serve the person. Is that correct? Yes.
Hi, I'm Gary. I work with
Gary's going to supplement what I said.
in response to your question, if a person has not been served, normally, and a judge can, the petitioner can request that a private process server serve the person. So sometimes the person is not home when the sheriff comes by, but a private process server, they have the time where they can go and do the research and follow them and find them. So a judge can order that.
Is there a cost to that for the person who's doing?
You would have to pay the private process server, nominal fee. They don't charge that much, but you could find out from them what their charge is. So, it is possible to get them served that way.
Thank you, Gary.
And the judge will, if not just one time, they will extend that injunction for a few times, you know, to make sure that the person gives them a maximum chance, you know, to serve that person.
How much time is there between this? So if someone really has a concern, so you're waiting 15 days for the hearing, and then the person's, you know, evaded the police, and then is there another 15 days for the next hearing? I'm just kind of concerned about.
Usually, yes, but remember that in a lot of these cases, the judge has granted a temporary injunction. Most of the time when they set a hearing, not always, there's a temporary injunction, so they're protected in the meantime.
Yes, and generally, you know, it says within 15 days, but sometimes the days go that it's not always 15 days. If you go to court and you ask for an extension, generally it's set within 2 weeks. They can do it within a week, and then if it takes a while for a person to be served, sometimes they can push that time out to 3 weeks. And it's even more when you have an injunction and the person is out of state. We like to extend it for a nice amount of time, for like a month or 3 weeks, to give them time to get, because we have to mail that to the state, out of state, to give them time to serve that person. So it doesn't have to be 15 days, but if the petitioner requests, you know, for another week, you know, if it's a local address, the judge, you know, may grant your request.
And they could just keep pushing that temporary one in the meantime?
Yes,
They
they will
have the
sign.
option to do that? The
Yes,
judge
they
would?
do, yes, yes.
Yes, ma'am.
For the injunctures, would this be something offered and even suggested to a survivor? If like the criminal case was dropped or the perpetrator was found innocent for whatever reasons, that there wasn't a strong case, but they still felt that there was a threat to where they would go and file the injunction for protection?
They can still, because the bar for a criminal case is higher than the bar for a civil case, which requires, you know, proving beyond a reasonable doubt. So that doesn't preclude them from applying for the civil injunction for protection. Also, even if they in the criminal case there was a restraining order granted, sometimes people still apply for an injunction because a restraining order may not address children, support, who's going to use the home. It may not go into as much detail as a civil injunction filed in the family court will. So definitely not mutually exclusive.
Yes, generally, you know, if a person gets arrested, there would be what they call a no contact order, which is a criminal term. In the injunction process, it's a civil matter. So therefore, if the no contact order is dropped in the criminal case, that's fine, you know, they can pick it up as a civil, in the civil injunction. You know, so if a no contact order is dismissed, you know, and you can still file a civil injunction, and that would still give you protection, you know, so you wouldn't have to worry about that. We have a special division called the trial division, TD division, that if a person gets arrested on a misdemeanor battery charge, and they file an injunction, we'll assign it with the TD division, which is a criminal division. And that's why we're called the Unified Family Court. We keep them all together, you know, so the judges would know what's going on instead of separating them.
I have a question.
Yes.
I don't know if you guys went over it before we arrived.
Yes.
We don't apologize for that. But if somebody have a domestic violence case, and how do they qualify to get the service for the injunction and
To get
for
the
divorce
service?
as well?
To get to get someone to serve the papers, or yes, we did cover how you qualify for all the different injunctions, but my entire presentation is on our website, so I will tell you where you can find it.
For free service.
Okay.
It's free.
What can happen generally is a person comes in and files an injunction. We'll refer them to a unit of victim services. They will speak to them, or either the sheriff's office. We also have advocates from the sheriff's office that help the victims also, do a great job. And once they speak to them, they get an injunction or they get a hearing set, they will refer them to legal aid. Legal aid will assist those victims, and then they will also come to court with them. You know, once you come to court, you get to talk to legal aid. You'll say, by the way, you know, I would like a divorce. And they may help you with your divorce at no charge. And there's no qualifying for legal aid. You know, it's a free service that they provide.
It is a free service, but they do have limited staff, and really they're one of the few organizations in Palm Beach that offers that service. So they can't take everybody who comes, but it's definitely worth contacting them and seeing if they can assist you.
I had someone contact them recently, and they said they don't help with divorces.
Well, they won't get involved with divorces if you don't have already an existing injunction.
Correct.
Because, you know, they have so many cases, they would like to help you, but they streamline the process down that if you have an injunction, then maybe we'll assist you with that.
And also, I mentioned at the beginning of the workshop, so I'll repeat it since you weren't here. At the self-service center, as far as the divorce goes, we can assist with the injunctions for protection. But as far as the divorce goes, we do have attorneys that can help with completion of the forms. They cannot give legal advice, but they can help go through the paperwork page by page. It's not free, but it is low cost, $1 per minute in increments of 15 minutes. So if somebody needs assistance with the divorce part and we're unable to get assistance elsewhere, that may be another option for them. Okay.
How does the computer issue come in as far as an injunction? Because usually it's if they're face-to-face with you, but what if they are stalking you online and doing something like that? How do you police and tell them?
Well, what we discussed earlier in the workshop, it's okay, is that the injunction for stalking includes cyber stalking, includes electronic harassment, so that they would use that petition to explain it. And because it's electronic, there's a lot of difficult things about that, but there's one positive thing about it. A lot of times you can print out your proof, whereas when you're talking to someone on the phone, it's harder to do that. So in those cases, you can print out the Facebook screenshot, you can print out the messages, you can contact the carrier or from your computer. Nowadays, there are ways to get a printout of the harassment that's going on, which you could attach as evidence for the judge.
But what if they put things on Google about you? What if they put in your old address on there? You know, some things are public record, you know, but some things are not. You know, and you know it's that person who's doing it, but...
Well, that would depend. You would have to be able to prove that they was specifically directed at you by that person, continuous, for no legitimate purpose, and causing you substantial emotional distress. That's the definition that they have. And so you would explain it to the judge and provide your evidence, and ultimately that decision would be up to the judge if it rises to the level of an injunction. Anyone else? Great. Well, thank you everyone for coming. As I mentioned, we do have the petitions there. If you'd like to take one, just take a look at them. But they're all available on the clerk's website as well as the Florida Court's website as well.